Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. So, this is a Diddy quick update. I know you guys have already seen, but I got to do what it do on my channel and pull up the court doc and read it with you guys. Without further ado, let's go ahead and get into that. So, as you all have heard, and I have been speculating, Diddy was denied bail. Okay, Diddy was denied bail. Here is the order, the signed order for Judge Subramanian. I hope I'm saying his name right, but this is what his order reads. Defendant Sean Combs renewed his motion for bail on November 8th, 2024. The court held a hearing on November 22nd, 2024, and the parties filed supplemental letters on November 25th and 26th, 2024. For the following reasons, Combs' motion is denied. All right, and then the judge went and broke everything down as to why the motion was denied. So, section 1, it says no condition or combination of conditions will reasonably assure the safety of the community. Because remember the letter I was reading yesterday, the defense was trying to make it as if the government's only stance was he was a flight risk, and that was not the case. The case was it was more than him just being a flight risk. He is a danger to the community based off of the things that he has done in his past. So the judge states that the court has evaluated each of the factors that it must consider under Title 18 of the United States Code, Section 3142G, where it states nature of circumstances of the offense charged, weight of the evidence against the person, history and characteristics of the person, nature and seriousness of the danger that would be posed by the person's release. Then the judge cited United States versus Zhang, where it was stated that the courts have broad discretion in weighing the factors. The court also has reviewed the information submitted by Combs and the government across all three bail hearings in this case. And they just list the docket numbers that we can refer to. And so, pretty much everything that has been submitted, the judge has reviewed. The court finds that the government has shown by clear and convincing evidence that no condition or combination of conditions will reasonably assure the safety of the community. In support of this finding, the court provides the following reasons. Reputable presumption of detention applies to this case. Even if Combs successfully rebutes this presumption, which the court assumes here, it remains one of the factors that the court considers in determining whether the government has met its burden of persuasion. And they cite United States versus Mercedes. 2. The indictment charges Combs with serious and violent crimes. It alleges that for decades, Combs abused, threatened, and coerced women and others around him to fulfill his desires, protect his reputation, and conceal his conduct. To do so, Combs relied on the employees, resources, and influence of the multifaceted business empire that he led and control, creating a criminal enterprise whose members are associated, engaged in, and attempted to engage in, among other crimes, sex trafficking, forced labor, kidnapping, arson, bribery, and obstruction of justice. So, and I'm kind of taking this back to the Michael Jeffries case. Michael Jeffries has not been accused of any of this. That's why he is out right now on a $10 million bail. So people is like, well, why is Jeffries out and why Sean Combs is not out? This is not a race thing. We have to look at what has been brought to light. Jeffries, in that complaint, nothing alleged anything outside of the nasty stuff that he did in trafficking. Okay. Diddy has done far worse, and the court sees that. Let me see. It says docket one at paragraph one. It states that Combs himself carried or brandished firearms to intimidate or threaten others, including victims of and witnesses to his abuse. And it notes that during searches of Combs' residence in March 2024, states law enforcement seized firearms and ammunitions, including three AR-15s with defaced serial numbers, as well as a drum magazine. Let's see. 12, paragraph 12D says when Combs' authority or reputation was threatened, the indictment alleges he and members of his enterprise engaged in acts of violence, threats of financial and reputational harm, and verbal abuse. These acts of violence included kidnapping and arson. The indictment also charges Combs of sex trafficking in violation of Title 18 of the USC Section 1591. Let's see, and just zooming into that Title 18, it states that requiring the court to consider the nature and circumstances of the offense charged, including whether the offense is a crime of violence, whether it is a violation of Section 1591, and whether it involves a controlled substance or firearm. Third reason, the government has presented direct evidence of Combs' violence. This includes a video footage from 2016. There is clearly violence even in the version of the footage submitted by Combs. Because remember, they brought in the forensic person saying that this video was altered. I don't care however way you chop it up, you still going to see him throwing a vase at her. You are still going to see him dragging her down the hall by her hair. That is violence. Okay. Also, text messages between Combs and victim one, who we know is Cassie Victoria. Docket 19, it says at 10, text messages from the hours and days following the 2016 Intercontinental Hotel incident reads, this is what it read: I have a black eye and a fat lip. You are sick for thinking it's okay to do what you have done. I still have crazy bruising. And then they, I guess, put another text message. They didn't do that. Da da da. Nevertheless, Combs argued that the weight of the evidence does not support a charge of sex trafficking. In his view, it supports at best, a toxic, sometimes violent, long-term relationship between Combs and victim one. uh the filing at, which is docket 61 at paragraph 1, it states, but regardless of whether that's true, there is compelling evidence of Combs propensity of violence. Again, referencing Title 18, it says requiring the court to consider the history and characteristics of the person. So just in that video alone showed that he was violent. Do y'all want him back into the community? Fourth reason, there is evidence supporting a serious risk of witness tampering. For example, initiated and had unexplained communications with witness one, who was subpoenaed to testify before the grand jury in June of 2024, and in fact testified on July 25th, 2024. And it states docket number. Combs was represented by counsel during this time, and they have offered an explanation for some of these communications, but they cannot explain them all. For instance, Combs' efforts to call and text witness one even after his grand jury testimony, or Combs' deleted text message with the witness. Because he is still, what did I tell you? We talked about this last night. This man does not follow rules. He does not care. He is still doing the same thing even in jail. Why would they let you out? So you can have even more freedom? No. Let's see, where did I left off at. It says, although the phone records confirm that the defendant using a particular phone number and witness one exchange multiple text messages from June 2024 through August 2024, there were no such messages recovered from Combs' cell phone associated with that number. Further, Combs' interactions with witness one are directly in conflict with defense counsel's representations to Judge Carter on September 18, 2024, that Combs did not reach out to grand jury witnesses. He didn't do it and he wouldn't do it. I remember that. And I said that I don't know, like, are they slow? Are they really not checking on what their client is doing? Because you're straight up lying. I honestly don't think y'all have any say. Combs is running y'all, and y'all are not doing what y'all are supposed to be doing. This man ain't listening to nobody. Reason five, there is evidence that Combs violated the BOP regulations during his pretrial detention to obscure his communications with third parties. He paid other inmates to use their phone access code, which is known as the PAC numbers, to make calls to those not on his approved contact list. So docket 69, I don't know what letter that is, but at 17 and 18, it stated that it instructed family members and defense counsel to add people to three-way calls so that their communications were more difficult to trace. Because mind you, if they're doing three-way, they can't track that. Now, I don't know how that system works. Normally, if you try to do three-way, the call will hang up, but I guess not. And use a messaging program called Contact Me ASAP, because remember that the attorney said he stopped using it, and then literally on Sunday he used it again. Although the court recognizes that the parties dispute whether Contact Me ASAP is permitted or not, the government gives examples of Combs' communication utilizing these means from a recently as November 4th, 2024, directed to efforts to influence the jury pool. Docket 69 at 19 and 21, or to reach out to potential witnesses, and then that's at paragraphs 21 and 22. The court makes no determination that the content of Combs' communication through these channels were improper. However, his willingness to skirt BOP rules in a way that would make it more difficult for his communications to be monitored is strong evidence that the court cannot be reasonably assured as to the sufficiency of any condition of release, especially given that they occurred when Combs was seeking bail and when he knew the government's concerns about witness tampering and obstruction were front and center. Let's see. Underscoring the court's concern, despite defense counsel's assurance to the court at the November 22nd, 2024 hearing with Combs in attendance, that Combs stopped using Contact Me ASAP as of November 16th, 2024. And remember, at that hearing, they stated that he wasn't using it no more, but the government found out that he was using it as what, recently, this past Sunday. 6, the court further notes that it held an emergency hearing on November 19, 2024, to address the government's usage of notes on legal pads recovered from Combs' bunk during a sweep of the MDC. At the hearing, defense counsel advised, this is what they stated: all these pads say legal. Yes, they are marked legal. And that is in whatever submission they put, which is at docket 88. After the hearing, the court inquired why, in light of counsel's representation that the notes at issue were on legal pads that were clearly marked as legal, photographs taken during the sweep show no such labels. So y'all just flat out lied. The letter that was submitted and known as docket 77 at the November 22nd hearing, defense counsel admitted it has to be the case that as of the day of the search, legal wasn't written on every legal pad, and that they were not sure whether the pad presented to the court had legal on it at the time of the sweep. The circumstances of this incident and the misrepresentation made at the November 19th hearing, where Combs was present, bear on whether the court can reasonably assure that any conditions it imposed will be followed, or whether through inadvertence or active subversion they will be broken and the community's safety threatened. Like I said, the man don't follow rules. 7, Reason number 7, the court assumes that it may consider the bail package that Combs had proposed. But if you see United States versus Bustani, they stated in that case that we now expressly hold that the Bail Reform Act does not permit a two-tiered bail system in which defendants of lesser means are detained pending trial while wealthy defendants are released to self-funded private jails. However, given the nature of the allegations in this case and the information provided by the government, the court doubts the sufficiency of any condition that place trust in Combs and individuals in his employ, like a private security detail to follow these conditions. Hey, Buttercup. United States versus Arena. In that case, it stated proposal at best elaborates replicates of detention facility without the confidence of security such a facility instills. The court observes the pretrial services reached the same conclusion, noting at November 22nd hearing that the conditions are insufficient and that there are no conditions that could reasonably assure the safety of the community. What's up, MEP? The 8th reason, finally, the facts and circumstances here differ from those in Combs' principal cited authorities. United States versus Fox states that the Second Circuit recognized the case presented as an extremely close call, and that any loosening of conditions or more compelling evidence presented by the government could well tip the balance in favor of pretrial detention. But in Fox, the Second Circuit did not address a risk of obstruction, and the government failed to engage with the proposed bail restrictions. Now we're coming into United States versus Jeffries. While the government raised danger, its principal concern with respect to defendant Michael Jeffries was flight. Okay? So y'all have to understand, in Diddy's case, it wasn't just the flight risk, it was the past criminal history and all the other criminal, stuff that he has going. With Michael Jeffries, it was the only issue was him being a flight risk. He had no other criminal history. The alleged criminal conduct, which did not involve the kind of violence or RICO allegations in Diddy's case, abated nearly a decade ago, and Jeffries was 80 years old. So, what they're saying, if he did have any type of criminal conduct, it was more than a decade ago. With Combs, it was ongoing. It never stopped. Even when he even when he got arrested, it never stopped. That's what we have to take into consideration. Mm-hmm. Section 2, Combs' motion for temporary release is denied. So while they sat there and got whatever apartment they did and installed the cameras and all, I know they pissed. It says the court also finds that Combs has not shown that a temporary release from detention pursuant Title 18 of the USC is warranted. Under this provision, a judicial officer may permit the temporary release of the person in the custody of the United States Marshal or other appropriate person to the extent that the judicial officer determines such release to be necessary for preparation of the person's defense or for another compelling reason. Whew. Combs' application under Section 3142I is based on the conditions at the MDC. Because remember, he was saying the MDC is just horrible. He can't speak to his lawyer when he wants to. They can't have a private room. He just can't prepare for trial. And then the government said, yeah, we can because you have access to a private conference room 7 days a week. What are you talking about, man? Then you're saying that they're always on lockdown or whatever the case may be, and the government came back with receipts to say otherwise. Let me see. But given Combs access to counsel and documents, there was an issue with Combs receiving a laptop for the purpose of reviewing discovery, but the court addressed that. The firm deadline for the government's discovery is going to be December 31st. And the time left before trial is over 5 months because it's not scheduled until May 5th. Combs has not carried his burden of demonstrating that a release from detention is necessary for trial preparation under the purposes under Section 3142I or the Constitution. But the court will promptly address any issue that arises with respect to Combs' trial preparation. If the circumstances materially change, he may renew his application under Section 3142I. This motion is denied, and the clerk of court is respectfully directed to terminate docket 60. And docket 60 is his motion for bail. So they're going to terminate that. Baby, what? What did I tell y'all? I sat up here and I told you guys that in my opinion, he was not going to get bail. He was not going to get bail, and the judge was not going to allow him to get bail. Um, I wish that people sit down and take a piece of paper and look at the allegations, because I feel like this is going to be a big debate and people are going to try to turn this into a race thing. Well, once again, Jeffries is out and Combs is in. We can't do that. We have to look. Jeffries, the only issue that the government had, was he may be a flight risk. They're not worried about him, using other people's pack numbers and calling and all this other stuff, because he's out. He's out on a $10 million bail. He already gave up his passports. He's good, but he does not have the history and the ongoing history as Sean Combs. So y'all have to make sure that y'all understand this, and y'all see this is simply not a race thing. These is looking at the allegations that has been brought forth. Look at everything that Combs is doing, even in jail, in this facility. He's not even following directions in the facility, and you want the court to sit there and grant you release? So you're using the excuse for you to prepare for trial. My boy, yeah, I know you got to prepare for trial in this case. You got to prepare for the 120 lawsuits that has been filed. Hey, Mo. So yeah, you unfortunately you have a lot of work cut out for you, but definitely I would not allow you a laptop. No, sorry, Bob. You don't even have a laptop, and look what you're doing. You're telling and you keep submitting a bail package and telling them all of the conditions and things that you're going to do. No, no, Michael Jeffries, he's the former CEO of Abercrombie. So he was actually arrested for some nasty stuff that he was doing, and he was granted bail. So if y'all, I have done a video on that. I Yeah, I did a video on that. If y'all just scroll through the videos and look for I think I called it former CEO Michael Jeffries. So yeah, Jeffries, not Jeffrey Epstein, but Jeffries. But yeah, so Jeffries is out on a $10 million bail. He has no criminal history. Whatever he did was more than a decade ago. That's it. That's all. Combs, that's different. They're not just worried about him being a flight risk. They are worried about him continuing to do what he is doing now in jail, but even worse. So we got to take that into consideration. Once again, this is not a black and white thing. These are laying the alleged facts on a piece of paper and seeing that Sean Combs does not need to be released. We need to understand that he does have reasonable accommodations at MDC. All right. Yes, he doesn't have a laptop. He doesn't need a laptop. You know why? Because if he's sitting there using other inmates' PAC accounts, calling his family members and having them three-way, paying people to do this and that, absolutely not. I don't feel bad for him. But Y'all tell me what y'all think about this. Do you think he should have been granted bail and why? I want to know. Let's have an honest discussion. Thank y'all for tuning in. Replay game, what's up? What's up? What's up? Y'all, I hope y'all have a safe. I hope y'all out here shopping or getting last minute stuff so y'all can start cooking. I might go live tomorrow. I don't know. I'm gonna be at my in-laws' house. But it's always a pleasure to speak with you guys, right? But I had to bring up this update for you guys before we hop on into doing all this cooking, all right? Anyways, don't forget to comment. Don't forget to like, share, and subscribe. Until then, be blessed and I'm out. Bye, y'all.